yesterday. She, the day before, decided that none of our witnesses were relevant. She made them all come on through Skype, and we asked them the questions we would ask them if they were on the stand and in front of the jury. And she basically said that the right to witnesses was not an unlimited right. She quoted some case where the case law was basically stating that a person couldn't call, we'll just say like 100 witnesses to say the same thing.
Not entirely unlike the government did with you guys, right?
Exactly.
Yeah.
Exactly. I believe they called 30 witnesses last time, something like that. That all pretty much said the same thing. On our side, we had about 5 or 6 witnesses, and they weren't saying the same thing. They were from different areas. Some were at the stage area, some were down in the wash, some were down up on the bridge. And basically, she just said that any of the stuff that they were saying is irrelevant. That's because she's decided that self-defense is not a defense in my case. When you're dealing with assault on a federal agent, that there's two parts to that self-defense claim, and one is that you weren't sure that they were federal agents, which I've said in every one of my interviews that they all had compact gear on. We didn't know who they were. We thought the BLM had left. They were wearing multi-cam masks. So from 200 yards away on the bridge, I really wasn't sure who they were. Definitely didn't know who the snipers were up on the bridge. And then the other is that the amount of force one is reacting to was excessive. And the force used to react was no more force than is necessary. Our standpoint is that is the case of what happened. When I walked on the bridge, we saw them pointing weapons at protesters. Didn't do anything at that point except watch. And when we heard them say lethal force had been authorized and that if they took another step they would shoot, they took cover. Only took cover. We don't. Our position is it wasn't more force than was necessary. It was prepared to defend ourselves. There was no actual self-defense. That they just keep trying to say that we attacked them, that I attacked them. So basically, she says that there is no self-defense. Defense. And in that means that we cannot call any witnesses that would go to self-defense. So she's basically said that anybody that says that they were pointing guns at them and that they were afraid they were going to die, it would go to that self-defense. And which I don't feel is the case, even if they're not going to give us the jury instructions for self-defense and defense of others. You still have to show the facts. I should still be able to show the facts of what happened. She's repeatedly said the jury is the decider of the facts.
The trier
She's
of
the
facts.
decider of the law. Yeah, the trier of the facts. And she will interpret and give the law, and they will interpret the facts. Well, she and the court are not allowing the facts to come into play. And that's basically where we are with witnesses. So the next day, to decide that I left my home in Idaho to extort cattle, to travel to Nevada and extort cattle. And if we can't talk about why I left my home in Idaho, then we're leaving that element of the charge open. And she won't allow us to talk about, the motion wouldn't allow us to talk about what happened before the 12th, which was the stuff that caused me to get in my truck and drive to Nevada. So when I first brought that up on the stand, the government objected, and I think I said I saw a video. I was trying to be as vague as possible, but he asked me, he said, well, why did you go to Nevada? And I said, because first I saw this video. And not to mention, they brought in my Facebook, so they brought in evidence, of these articles and videos I shared. And they're using my statements and my text in those Facebook posts against me. And when I go to explain what the actual article was or the video and try to put that text into context, they object, and she sustains it. All I said was video, and they objected. I didn't say a video of Bundy being tased and Margaret Houston being thrown on the ground and people being arrested for not being in a free speech zone and dogs being sicked on people. So we moved on. They went into sidebar and argued for a minute, and then we moved on. She sustained their objection. We couldn't talk about anything prior to the 12th, even though the conspiracy allegedly started prior to the 12th. But as we moved on, she had said that I can talk about things I saw and things I heard, but I can't talk about how that made me feel, which completely contradicts my intention. The government has put on their case and tried to show my intention through their evidence and implied what they believe my intention was and is. And now I was unable to talk about what my intentions were and what I feel my intentions were, what I know my intentions were. But I can talk about what I saw and what I heard. And so we get to the point of the bridge, and one of the agents, I won't say her name, they get mad when we talk about their names, but one of the agents said that I pointed a firearm at her, and she cried on the stand, and it was a very theatrical thing. But she also said where she was. And my lawyer puts up a map and says, okay, could you see this area? And circles it, and that was the area where that agent was. I said, no, I couldn't. There was, I drew a line where there was a hill in the way from my line of sight when I was at the parking area. And then I told him when I got to the bridge and there was an open line of sight to that area, it was 500 yards away. I didn't know there was anybody over there, and I was watching other things. I have to say, I'm on the stand in federal court, and instead of explaining what and why, I have to say other things. And I circle what those other things are, and those are the vehicles with plainclothes and multicam, what I back and she said, well, the government's motion is granted, and Mr. Parker, you can go sit down. I stood up, and I didn't understand. I thought maybe, I was trying to understand what was happening. I was pretty blown away. Marshall came over and said, let's go. And I walked off the stand and went and sat down, and she closed court for the day, ushered the jury out pretty fast. I wasn't really watching the jury. I was, like I said, I was pretty blown away. And apparently they looked pretty confused themselves. And she ushered them out pretty fast and said court's adjourned for the day. See you on Monday.
So, Eric, a lot of people are talking, and a lot of people obviously are curious about what happened yesterday. The other thing that people are talking about is mistrial. There's a lot of talk about mistrial. So first part of this question is, what are your thoughts about mistrial, about your attorneys motioning for mistrial at this point? And number two, what are your attorneys saying about what has happened to you guys in the courtroom? The fact that you can't talk to your state of mind, the fact that you can't talk about the arrest of Dave Bundy on the 6th or Margaret or Ammon on the 9th, the fact that you can't talk about seeing militarized land management agents, the fact that you really can't speak to your state of mind for the reason that you went to Bunkerville. What are your attorneys saying about what is happening in this courtroom? Because all of us are on the outside looking in, and we are seeing terrible injustice and multiple violations of clear constitutional rights. And we just kind of think everybody's wondering, like, where are the attorneys' minds to?
Sure. And so there was a lot there. Let me start with saying it wasn't just their arrest. It was the way they were arrested. It was the violence that was used on them. The BLM, deployed military tactics on citizens. There were snipers, dogs, and they were assaulted. Not just arrested. They were assaulted, and those were the things that got us, that got our attention, and made us want to follow the protesters wherever they were. And secondly, I would say the lawyers have continually, since this thing began, said they've never seen anything like this before. Part of me feels sorry for them, because they've been put in a position where they don't know what to do. Like the statement I get from them most often is, we're just going to have to make the behalf and face my accuser. You know, it's every time I think that they've gone as far as they can, it seems like the next day there's some new insanity. The lawyers have said that if it goes bad and that they've never seen a case with so many appeals avenues. You know, but nobody wants. They also say, you know, nobody wants to fight a case to get to appeals. You know, they want to win. They told me yesterday on a break while I was on the stand that I had to keep fighting. That they were going to keep asking me questions, and I had to keep fighting. And while I was on the stand, I started to get a little docile. I didn't know. I was trying not to violate the court order, and I was trying to think of how I could say things. So it was taking me a minute, and I wasn't as assertive as I was the last time on the stand. And they said you gotta be more assertive, and you gotta look that jury in the eye, and you gotta keep fighting. Don't give up. Basically, you know, Jess told me at one time. He said, you know, he's been in cases before where his client was just belligerent and made him go to trial, and you know, a sex offender or a heroin dealer or whatever, and there was no case at all, and he just sat there for a week and got punched in the face. And he said it's so frustrating when he has a good case like this one, but his hands are tied and he can't fight. So they're frustrated, but I don't know that they know what to do. I mean, at this point, when I'm looking at it, they could rail against the system, but I mean, I imagine they'd be looking at losing their bar license, you know, their livelihood, and I understand that. You know, the other side of it is, you know, the government's trying to kill me. Something's got to give.
What are your thoughts about mistrial? There's been a lot of talk on social media and through various channels about mistrial, and some people have the argument that the way this is going, your attorney should have argued for mistrial a long time ago, and others say maybe at this point you should stick it out to the end because what have you got to lose? And so I think what's missing from that discussion is the perspective of a defendant. So. Yeah, what do you think about mistrial at this point? If you went in Monday and mistrial was an option, what would be your feeling? And maybe if you know what a couple of the other defendants think, if you guys have talked about it.
Talked about it a little bit. So first, we filed for mistrial a week ago in there, and it was denied. And now with all this stuff that has proceeded to go on, I think like reading tea leaves at this point. You know, I don't know. I can speculate, but that's about it. Never been in this kind of situation before, so I've got nothing to base it on. The outcome of a mistrial is, we go back to Abrupt and wait another 2.5, 3 months and come back and do it again. You know, are they just going to come up with more ways to, I don't even know how I'd want to say it. Are they just going to sit for 2 months and come up with more ways to mess with us and take our defense from us? I think that's very possible and likely. And then the other side is how many times are they willing to do this? You know, they've got 2 other tiers of defendants, I would hope that somewhere up the chain, if they can't get a conviction after a couple times, they would have to think about doing something different. One thing we were talking about is a motion to dismiss on an interlocutory appeal to the Ninth District of Appeals, and what that would basically mean is that we would file a motion to dismiss on numerous things. You've got prosecutorial misconduct, you've got vindictive prosecution, you've got I think we could write a pretty good motion to dismiss at this point, and send it up to the Ninth. An interlocutory appeal means that we wouldn't go back into court until the Ninth ruled on it. Kind of a way to put the brakes on it. If we do that, it's also similar to filing an extension, which would allow them to just keep us in jail as long as it would take for the Ninth, and as long as it would take for them to make a ruling, and then even after that, we would probably have to go back to court with, a set of rules put in place by the Ninth. That would be hopefully a little more fair, and at that point, could the court move our trial back even further? Basically, what I'm saying is, if we file that interlocutory appeal, we could be sitting in Abrupt for 2 years waiting for our trial again.
Well, that and relying on the Ninth Circuit is a terrifying proposition in and of itself.
It is. I think at this point, there is a lot of evidence for our side, for our opinion, for our view. But even with that, that's still a terrifying thought. Anthony, I just want a fair trial. I understand that some people don't.
You have 1 minute left.
Agree with what happened or my actions and everything else, but I just want a fair trial. If that ends in me being convicted, that ends in me being convicted. But I want to be able to call witnesses on my behalf, and I want to be able to tell the facts as I saw them and what actually happened in those couple of days. And I just don't understand, and I don't think that's going to happen.
Because right now the jury is only a trier of some of the fact.
Yeah, how do they decide? How do they judge the end if they didn't know or see the beginning? It's a fraud.
Thank you for using Securus. Goodbye.